that we have received online. We now have, again, 4 speakers to present on the topics of the standards and free, prior, and informed consent. And the first speaker is my co-director, Rachael Lorna Johnstone, and since she's already presented herself, I won't use a lot of words to do that.
Thank you, Anna, and thank you all for your patience in listening to me once more this morning, or this afternoon. So I'm going to talk a little bit about the United Nations system for protecting the rights of Indigenous people. And there are a number of fora in the United Nations. Most of these that we're more familiar with are the charter bodies, so the Permanent Forum, the Expert Mechanism and Special Rapporteur. But there are also some treaty-based committees that review Indigenous rights within a general human rights system based on binding treaties. And my work recently has been looking at what they've got to say about Indigenous participation, in particular the principle of free, prior and informed consent. So it is a long, and I could bore you to death by PowerPoint by explaining all these committees. I'm trying to keep it straightforward. So these are all the committees that deal with human rights based on binding international treaties. The ones I've highlighted are those that have the most to say about participation of Indigenous peoples in extractive industries. So the Committee on the Elimination of Racial Discrimination, the Human Rights Committee that focuses on the International Covenant on Civil and Political Rights, and we'll hear more about that from Eyvind Ravnar later, the Committee on Economic, Social and Cultural Rights, and the Committee on the Elimination of Discrimination against Women. The other committees on the list do address Indigenous issues, including, rather worryingly, instances of torture or disappearances of Indigenous people, often connected to extractive industries and land rights struggles, but they don't tend to address issues of participation as such. It's not within their mandate. So why look at the human rights treaty bodies? At the first World Conference on Indigenous Peoples, states from all over the world invited the treaty bodies to consider the declaration, that's the UN Declaration on the Rights of Indigenous Peoples, in accordance with their respective mandates. And the states also encouraged other states to integrate their activities and the UNDRIP in their state reports. So it's important to look at the work of the treaty committees because they're interpreting binding treaties. This is not quite the same as asking if the UN Declaration is customary law or even if free, prior and informed consent is customary law, but rather it's about asking what standards states have to meet vis-a-vis extractive industries under treaties, binding treaties they've already agreed to uphold as a matter of law. So these treaties are very widely accepted by states. Just some brief slides. All those dark blue countries have accepted the Convention on Elimination of Racial Discrimination as binding. We can see the same International Covenant on Civil and Political Rights, International Covenant on Economic, Social and Cultural Rights. You'll see in the Arctic, United States is pale blue. That is because it has signed this treaty but is not a party to it. We have the Convention on Elimination of All Forms of Discrimination Against Women. Again, United States is the outlier in the Arctic, having signed but not accepted as binding this treaty. Convention on the Rights of the Child, everywhere in the world has ratified it except the US. And the Convention on the Rights of Persons with Disabilities, again, extremely widely ratified, but not by the US. And there is a lot of lengthy explanations, and it's easy to scoff and laugh, but there are some constitutional reasons that explain the United States' position on women, on people with disabilities. It doesn't mean that they don't care about it, it's just that they don't do it through international mechanisms. So the key provisions, sorry about the death by PowerPoint slide, but the key provisions that you need to know to understand what will follow is that under the Convention on Elimination of Racial Discrimination, states' basic obligation is to integrate a policy of eliminating racial discrimination in all its forms and promote understanding among all races. The International Covenant on Civil and Political Rights, Article 27, doesn't protect Indigenous peoples explicitly, but talks about minorities. or rather, persons belonging to ethnic, religious, or linguistic minorities shall not be denied the right, in community with other members of their group, to enjoy their own culture, to profess and practice their own religion, or to use their own language. And the right to culture has been interpreted, as we'll see a little bit in Öyvind's work, to extend to traditional economic activities, even when those economic activities are carried out on a commercial basis, as long as we can see that historic continuity. International Covenant on Economic, Social and Cultural Rights upholds the right of everyone, not just minorities or indigenous groups, to take part in cultural life, and that's also relevant to extractives, where those industries can have negative impacts. And both the covenants, the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social and Cultural Rights, uphold the right of all peoples to self-determination. And as part of that, an integral part of the right to self-determination is the right of peoples for their own ends to freely dispose of their natural wealth and resources. So the committees operate by reviewing state compliance through the state report process. So every few years, the state will send a report to the committee explaining what it's done to try and implement its obligations, and discussing any challenges that it's experienced. And the expert committees, that usually have 18 to 23 expert members, interview the state. They have a dialogue for, it's only about 5 hours, it's not very long, but they then interview representatives of the state, and this results in concluding comments or observations on the state to see what the state's doing well, and almost always recommendations for improvement. There are also a number of important communications, and this is when individuals and sometimes groups send letters to the committee saying that their rights have not been upheld. Most importantly, in the Indigenous extractive tension is based on Article 27, the right of persons belonging to minorities to enjoy their own culture. We see those cases from Canada, Lapland and Peru especially. And that's under the jurisdiction of the Human Rights Committee. But it won't review Article 1, the right to self-determination, because of a technicality in the convention. The Committee on Elimination of Racial Discrimination has to date only had one case on an Indigenous issue, which it did not hold to be admissible, so it didn't consider the case on the facts. The Committee on Economic, Social and Cultural Rights could address Article 1, that right to self-determination, but that process is quite new and they've not had an opportunity to declare that. Now, there are some problems of relying on a human rights approach. It's not an exclusive approach. It's not going to solve all the problems of Indigenous peoples and all the challenges they face. So although the treaties were negotiated and agreed during or after the decolonization struggles in much of the world, most of them were finalized before Indigenous people's rights were recognized as being part of that struggle. So the term people in Article 1 and the people's right to self-determination was first written aimed only at decolonizing nations and not extended to Indigenous peoples. Later, though, we have seen moves within the UN system and amongst states to recognise Indigenous people's rights, but still not a willingness of states to accept that Indigenous peoples have the same rights as colonial peoples. So Indigenous rights as human rights is also a limiting approach because it's based on a liberal model of rights that looks at individual rights. And as you know, Indigenous rights can only be understood on a collective basis if they're to be meaningful. But there's also a deeper conceptual tension. So if we think again about the Convention on the Elimination of Racial Discrimination, it's based on a framework of treating everybody the same, about non-discrimination. And that's mostly how human rights is conceived of. It's about inclusion in mainstream society. But Indigenous rights are necessarily communal in many respects, which is problematic for the classical rights model. But even more problematic is that in many cases, Indigenous peoples are not asking for inclusion. They're asking not to be part of mainstream society, not to be assimilated, and asking, at least in some respects, to remain outside of mainstream society. In other words, they're seeking a right to be different and to be treated differently, and that's essential to their very survival. But that's at odds with the basic premise of a non-discrimination convention, to treat everyone the same. And another problem of the treaty system is that all these committees of experts, of all those, there's actually 10 committees. There is one Indigenous expert on all those committees, and he sits on the Convention on Elimination of Racial Discrimination. That's in contrast to the charter bodies, the Permanent Forum, the Expert Mechanism, and the Special Rapporteur, which do have much greater involvement of Indigenous people directly. Nonetheless, it is a pragmatic approach. Indigenous rights as human rights won't solve all the problems, but it does give us legally binding treaties and mechanisms whereby we can have review of state performance on Indigenous issues. So back in 2015, the current Special Rapporteur on Indigenous Peoples, Victoria Tauli-Korpus, said that human rights treaty bodies have consistently affirmed the principle of free, prior and informed consent of Indigenous peoples in matters relating to their rights and interests, and specifically in relation to their ancestral lands and conservation. But I want to look closer and see how they've affirmed free, prior and informed consent, or FPIC. Is it something states must do as a matter of law in order to be compliant with the treaties? Is it a good faith process that you have to try to get free, prior and informed consent? Or is it actually an outcome? Is it a veto? In short, does no mean no? So certainly an original interpretation of the treaties would not endorse a FPIC as a veto approach, given that some of these treaties are 50 years old and there was no idea, there was no conception of Indigenous rights as being part of the system, let alone the idea that Indigenous communities could stop developments. But treaties have to be interpreted over time, dynamically and contextually, taking into account more recent developments on similar issues and in related areas of international law. And in this case, we could argue the UN Declaration, and in fact, that's what the committees do. So the Committee on the Elimination of Racial Discrimination has been addressing Indigenous peoples for 2 decades, including an important general recommendation in 1997, where it talks already, this is 10 years before UNDRIP, about informed consent as necessary for any decisions affecting Indigenous peoples, and especially recognise their rights to lands, territories and resources. From 2007, after UNDRIP was adopted, the committee has asked states to use the UNDRIP as a guide to interpret obligations under the Convention relating to Indigenous peoples. And that's very interesting in 2007 because that statement was addressed to the United States before the United States had come out in favour of the declaration. The United States was one of 4 states that initially voted against the UN Declaration on the Rights of Indigenous Peoples. And in the same report, they call on the United States to consult and cooperate in good faith with Indigenous peoples as regards extractive industries. But they didn't then talk about FPIC as such. In 2009, the CERD, or the Committee on Elimination of Racial Discrimination, made a very important statement about Indigenous rights, which I'd like to highlight. And it clarifies the distinction from what they call temporary special measures. Temporary special measures, we sometimes call that affirmative action, maybe a quota system for people from disadvantaged communities. Indigenous rights are not that. They're not temporary and they're not special. They're permanent measures based on the rights of these communities, as Indigenous peoples. So this is not about catching up. It's not about rectifying past discrimination. Rather, Indigenous rights are permanent rights based on their rights to exist as peoples. The Committee on Elimination of Racial Discrimination addresses FPIC explicitly in a number of state reports, including in Norway, expressing concern that the Finnmark Act is inadequate, but it does seem to be approaching free, prior and informed consent as a good faith process rather than as an outcome. Next door in the Human Rights Committee, which is governing the International Covenant on Civil and Political Rights, has considered a number of communications. So there's quite a large body of case law on the rights of persons belonging to minority groups to enjoy their culture on an effectively collective basis. One of the most important of these is the 2009 decision, Poma Poma versus Peru. And in this case, the Human Rights Committee recognized that raising llamas is an essential element of the culture of the Aymara community, since it is a form of subsistence and an ancestral tradition handed down from parent to child. And the committee considers that participation in the decision-making process must be effective, which requires not mere consultation, but the free, prior and informed consent of the members of the community. As regards Sweden, the Human Rights Committee suggested that consultation aimed at free, prior and informed consent would be sufficient, that is, a good faith process, but not necessarily an outcome. And similarly, the committee called on Namibia to seek the free, prior and informed consent of Indigenous communities and give primary consideration to their opinions and decisions prior to granting licenses to extractive industries. But that's still short of a veto. It's still short of saying that no means no. Committee on Economic, Social and Cultural Rights is also addressing states and asking them to consult and seek consent in 2005, so slightly before the UN Declaration was agreed. It's been more willing than the Human Rights Committee to look at self-determination issues under Article 1, for example, in respect of the Sami in Lapland. In 2011, the committee issued a general comment on the right to take part in cultural life, that's Article 15 of the Convention, in which they addressed the rights of Indigenous peoples explicitly and concluded with a broad provision that state parties should respect the principle of free, prior and informed consent of Indigenous peoples in all matters covered by their specific rights. Messages, however, on free, prior and informed consent are mixed in the state report process. In some cases, the indication is that free, prior and informed consent is a process issue. It's what you have to consult in good faith in an effort to obtain consent. For example, in Finland, the committee urges Finland to seek the prior, free and informed consent of the Sami people before granting licenses to private companies for economic activities on territories traditionally occupied or used by the Sami communities. And it took a similar approach in Sweden and in respect of Canada. However, in dialogue with Guyana and the Philippines, the wording indicates that it really is about outcomes, that consent must be obtained to legitimise development projects on Indigenous land. So here we're seeing that free, prior and informed consent must be obtained. Moving on then to the Committee on the Elimination of Discrimination Against Women, they have been approaching issues of participation of Indigenous women in the decision-making process. But also interestingly was that in its general inquiry into the problem of the missing and murdered Aboriginal women in Canada, a topic that's not obviously connected to extractives, now there are links, but it's not an obvious one, the committee nonetheless brought in the issue of FPIC and deliberately referred to the right to free, prior and informed consent. But while concerned about the full participation of Indigenous women in decision-making processes, it does seem to be sticking to a cautious free, prior and informed consent as a process rather than as an outcome, as a process, a good faith consultation rather than a veto. For example, asking states to systematically consult and seek free, prior and informed consent. There are two other committees that I think could be doing better, especially we heard this morning about the problem of engaging the youth. So although the Committee on the Rights of the Child issued a general comment on Indigenous children in 2009, it doesn't address land and resource issues. In its dialogue with state parties, it asked states to consult and cooperate in good faith with the Indigenous peoples concerned, including Indigenous children, in order to obtain their free, prior and informed consent before adopting and implementing legislative or administrative measures that may affect them and provide effective remedies in cases of violations of their rights. But this is not clearly about resource rights. It's not clearly about FPIC in the situation of resource competition. And there does seem to me to be potential here to consider how Indigenous children and the youth participate in decision making. After all, they're the ones who will be living with the consequences for decades to come, both positive and negative. Also, the Committee on the Rights of Persons with Disabilities has not so far considered the impacts of extractive industries on the rights of Indigenous persons with disabilities. They do consider consultation with persons with disabilities in matters affecting them, with occasional references to Indigenous peoples, but they're not talking about extractives and certainly not FPIC, and I cannot find any references to the UN Declaration in their work. Indigenous peoples with disabilities are mentioned in the preamble to the Convention as amongst those subjected to multiple or aggravated forms of discrimination. But in my view, the committee needs to pay more attention to the challenges facing Indigenous people with disabilities, for example, regarding information in an accessible format and the opportunity to participate in decision-making, just physically getting into a building or having material accessible for the deaf or the blind. So to sum up, as we're trying to keep things to time, the two committees with the most obvious mandate on Indigenous land and resource rights are the Human Rights Committee and the Committee on Economic, Social and Cultural Rights. By virtue of that common Article 1, upholding the right of peoples to self-determination, but they're not that keen to use it. Rather, we're finding them applying the right to culture, often in preference to more politically charged arguments about self-determination to protect Indigenous peoples' land and resource rights. The Committee on Elimination of Racial Discrimination has also been proactive on protecting Indigenous peoples, notwithstanding that apparent incongruence of the individual rights and a non-discrimination and equal treatment standard and the Indigenous rights as the right to be different. But I do really appreciate them talking about Indigenous rights as permanent rights and not temporary special measures. The Committee on Elimination of Discrimination Against Women is also applying FPIC to Indigenous women's land and resource rights. The other committees are less responsive. Now, this can partly be explained by limited mandate. The Committee on Torture, Disappearances, or the Committee on Migrant Workers don't really have jurisdiction to look at land rights of Indigenous peoples. But there's a missed opportunity, in my view, of the Committee of the Rights of the Child and the Committee on the Rights of Persons with Disabilities. For example, the rights of those groups to obtain relevant information in a manner that's accessible to them and to participate actively in resource development processes. Thank you.
Have you turned this on? Yeah. Okay. Yeah. Great.
John Telling, Rachael, Greenland. When we discuss Indigenous peoples and in these forums and all these discussions, I always wonder where's the definition of Greenlanders, because I don't think we are. And, we make our own rules and licenses and so on. So how is this relevant?
Thank you. I had a suspicion that was going to come up. It's an extremely complicated and difficult question. So if we take it really strong view, we can take the Greenlanders as a colonial people with a full right to independence, just the way that Kenya can become independent, can run its own affairs, Ghana, as a colony of a European power with a full right to independence. Which in fact is more or less what's been agreed through the self-government and the process, the consultation and agreements made with the rest of the kingdom. As long as you're inside the Kingdom of Denmark views you as an Indigenous people within Denmark. And when you become independent, then you have a whole new set of questions that arise. But as long as you're in this kind of like limbo, in this not quite independent, but certainly not dependent either, at least, and certainly not when it comes to extractive industries, it's an entirely domestic process. In my view, I don't think the Greenlandic government should lower the standards and the protections that would be available if you were still in the Kingdom of Denmark. So we can also talk about vested rights. So as long as, imagine we were still like, you were still just a county of Denmark, and you were just treated like Aalborg or wherever else, and you would clearly be an Indigenous people and you would have all these rights. So when the self-government comes in 2009, are you really going to tell people, well, we're just going to take those rights away now, you don't need them anymore? And that's not a position I'm terribly comfortable with, which is why I think that we should uphold the standards that have already been agreed, even if, or as you gradually move, by taking on more and more local power, by taking on more and more authority in the self-government, I don't think you should reduce the protection for groups. Then there's another more complicated question. I think most people in the room know that there are 3 dialects, or they're called dialects in Greenland, which we could also call languages. So the East Greenlanders and the North Greenlanders, irrespective of whether you want to call them distinct Indigenous peoples or just all one part of the Inuit, whether you want to consider all the Inuit as one Indigenous people right through to Chukotka, it's not really that, it's not so important when it comes to that Article 27 of the ICCPR, of the International Covenant, because it talks about linguistic minorities. So we have linguistic minorities that must be protected in this process. So when Greenland becomes fully independent, the question of are the Greenlanders Indigenous ceases to be relevant, but you have really big questions about do we have Indigenous peoples in East Greenland and North Greenland, and irrespective of the answer to that question, you definitely have linguistic minorities that should be protected.
Here, and then Hjalmar and then Lena.
Well, thank you. I think, Rachael, you basically answered my question already, but so I think I'll just pass. This is a huge discussion, and I think I will just save my questions for later. Thank you.
Okay, send den over til Hjalmar.
I think that the question raised is very important and important to discuss, also because it's been discussed for time immemorial. Who are who, and in regards to define a specific people or certain peoples is kind of a controversial issue also internationally. But as soon as you define yourself, you will be in a block without the possibilities to go out of it. That's the reason why we prefer to use the right to self-identification. People's right to identify themselves, who they are. That's my first input to this issue.
Yeah, I think that's a really important point, and I should have mentioned it, that in the sort of international understanding of Indigenous peoples, there is no one fixed definition, but there are a number of criteria. This goes back to a report called the COBO report by, I think, the first special rapporteur on Indigenous peoples. And probably the most important criteria is self-identification. Do you identify yourselves as an Indigenous people? So if you like, you could have a referendum and ask all the Greenlanders, do you want to be an Indigenous people or not? That might not be the most effective way to go about it, but it's certainly a discussion you're going to have if you become independent. Do we want to continue to uphold these standards? Another reason why being Indigenous or not is not necessarily all that important in the grand scheme of things when it comes to these processes is even people who are not Indigenous should probably be protected against extractive industries and negative impacts, and should have some kind of process. So we're going to hear from James later, and he's not talking about Indigenous people, but they're still talking about the importance of engaging local people, the ones who are going to bear the brunt of the impacts. We can also see case law from Latin America. So the Inter-American Court, am I talking really fast? Sorry. So the Inter-American Court on Human Rights has been quite progressive on protecting Indigenous peoples in Latin America. And one of its most important cases is a case called Saramacca. Now, Saramacca case was about a group who were not Indigenous by any traditional definition. They were a group of descendants from runaway slaves. So they were not Indigenous to the region, but they were tribal. They'd escaped as slaves and set up their own kind of tribal community outside of mainstream society. And the Inter-American Court held that they had to be protected to basically the same standards, and they had to be involved in participation and involved in benefit sharing. And that it was not acceptable to have developments go ahead that would violate their basic right to existence.
Yes, thank you for this presentation. It's really interesting, really opened my mind to all the different areas where FPIC can be found and interpreted. And actually, I did want to carry on with that that discussion because it is really important. And I work a lot in the sort of business side of interpreting these things, and increasingly there is an awareness that you need to be thinking about. Not specifically whether someone is Indigenous or not, but their relationship to the land, the cultural effects of the project on those people, and some, for instance, the Forest Stewardship Council now has said that FPIC should apply to any project-affected communities who are going to be have their sort of relationship to the land affected. So I think. Sometimes the arguments about whether someone should be called Indigenous or not gets away from the point that extractive industries can have a very big impact on people who are dependent on the land, and they should be protected for that reason. And by that token, in Greenland, you have people who, throughout Greenland, people are Greenlandic, and you have a Greenlandic government, but you do also have local people in those places most affected, who therefore deserve the rights of to be particularly respected and have their rights respected, and not just removed from the land in order to make way for a mine. So that's.
And this goes a little bit back to where is your consultation? Who are the people concerned? Some of the international instruments about participation, like Aarhus Convention, assume that we're going to talk to the people in the affected area. Now, how do you do that in Citronen? Because it's so far, it's like hundreds and hundreds of kilometres. Who are the people affected? But I think Emma really points to it. Wherever you look in Greenland, there are, well, maybe a little bit less in Nuuk, but there are people who are very, very dependent on the land, still have a very traditional cultural identification. It's not just about economics. Part of it's economics. People do depend on subsistence food from the sea and from the land. But it's also just about a cultural identification. Who are you if you're not a hunter? And that. So the question of indigenousness is really more a question about a relationship that you have with the territory on which you live and the resources on that territory. For brevity, I didn't get into that in the presentation. I thought it might come up, but so these committees are they're not looking specifically at Greenland. Of course, they have reports on the Kingdom of Denmark, and it's the Kingdom of Denmark that submits that report. And in the context of the Kingdom of Denmark, Greenlanders are one single indigenous people. So that's where it comes in, and they're not. So they're talking about the Greenlanders as indigenous, and that's why these sort of general standards of indigenousness are transferable, I think, to the Greenlandic situation, irrespective of how we want to define indigenous and how you want to define yourselves as Greenlanders.
So, okay. Just a small remark to follow up on what you just said. It's Denmark submitting reports, but Greenland certainly is providing facts and is all facts, and it's also has been promoting itself as an indigenous people in that context. Mm-hmm. So that's the reason why it's done that way.
Yeah, thank you.
I was thinking also in the former days. Pardon me? Oh yeah, my name is Benny Martinsen, and I'm a master's student here in Ilisimatusarfik. I have been thinking about the question, like from also the earlier session today. Have the big companies don't have a responsibility that they could be held accountable on social or environmental issues when they violate a contract? Mm-hmm. Or is it because they have more of as a soft law that they can escape from the contract and violate it?
So, if I understand you correctly, there is a whole chain of responsibility, and in international law, the buck stops with the government, and that right now is Copenhagen. That's the one who's got international responsibility. Greenland cannot, as an independent entity, be litigated against at one of these, or there cannot be a case brought against Greenland. It would be in the name of the Kingdom of Denmark. But as we know, that is now controlled by the self-government in Greenland, which has the responsibility to uphold these standards. And it has to do that by setting the standards for the companies and monitoring what the companies do and taking measures if they don't uphold those standards. So that's what we call due diligence, the duty of the government. I don't like using the word state because we have this kind of double state here. We have the kingdom and we have Nuuk. But that's the obligation, is to make sure that within your domestic legal system, you have institutions, you have set laws, that minimum standards that the companies have to meet, you have institutions to monitor what they're doing, and you have court institutions, for example, if you need to litigate against that company because it's not met the standards.
Now I was thinking of that, now we talk about human rights and so on, so I'm thinking of Thule area. Beginning of 1950s, people got moved from Thule to Ranach for losing their hunting areas and so on because of the Americans couldn't make a base up there. Yeah. And I'm thinking that for 1 week or 2 weeks ago, Canadian Prime Minister said excuse to the people of the indigenous people in Canada. And I'm thinking that we are still missing the excuse from the Danish government. And I know that ICC has been involving in that fight too, and I was thinking that there's still an issue to talk about when we talk about the human rights.
Yeah, so one of the most egregious violations of the rights of Indigenous peoples is forced relocation, where you move a people without their consent. And when the Tula people were moved, they were given like 3 days notice to pack their stuff and move, and they were promised rainbows and unicorns, which of course never transpired. That, unfortunately, in the 1950s was not considered a wrongful act. The state was regarded as having the power to do what it wanted with Indigenous peoples. It is certainly a wrong, it's certainly a political and moral wrong that has been done. I don't want to get into the debate about who should take responsibility or make an apology for that. As far as the legal process goes, there have been complaints, including to the European Court of Human Rights, the Hinkatak 53 case, and through the ILO Convention 169 process, both of which held that they couldn't hold this because they couldn't backdate the wrongful act to when the relevant treaty came into force, because the treaty came into force, both the European Convention and the ILO 169, after these events occurred. So as a moral wrong, yes, that's absolutely something that needs to be addressed, but I don't think I'm in a position to say how that should be done.
We attended a presentation at Arctic Circle last week from Inda Overland about a ranking system on performance on Indigenous people's rights. And he noted that, companies operating in countries such as Norway and Denmark, who have ratified the ILO Convention, still are some of the ones performing worst in relation to, respecting Indigenous people's rights. So does it even matter that we ratify these conventions?
Okay. So ILO 169 is a slightly different legal framework. But yeah, does it matter if all these countries are violating it anyway? I think that I wouldn't take that necessarily as a conclusion from Indra Overland's presentation, simply because he was doing a desktop study and looking at the paper processes that these companies, and it wasn't he wasn't looking at state standards, governmental standards, he was looking at individual business ventures above the Arctic Circle, and to the extent to which they were meeting obligations of international standards, but based on what they said they were doing. So he was comparing what companies said they were doing. Now, if you have a Greenlandic company, they maybe don't have it written into their process, we're going to consult with Indigenous peoples, because they're just going to call them people. So this might be a problem of comparing apples and pears. It might be that in fact what's actually happening on the ground is going quite well. It's just that it's not written into the framework in the language that is comparable to the international system, especially if you're not sure about using the word Indigenous. Companies working in Greenland may be very aware of that sensitivity and unwilling to talk about Indigenous peoples or communities. So I don't think it's necessarily saying that it's worse. In terms of do the treaties matter, I think they really do, in that no state has got this right. But I have a sort of general theory of international human rights law, which is that there will be some countries that will do what they like no matter what they ratify, and most of them just won't ratify. And there'll be some companies at the other end that will do really, really good job, whether they ratify or not, whether they're a party to the treaty or not. But there's an awful lot of countries in the middle that they are kind of well-meaning but not quite sure what to do, and they're genuinely listening. This is a dialogue, it's a constructive dialogue with these experts who tell the state, this is what I think you need to do better. And it's a state self-review, it's a self-report, self-evaluation. I guess this is all in all your workplaces now. You've got to do these periodic self-evaluations of how brilliant you are and all the things you can do better. But it does force the state to make periodic inspections of its own processes, not to take too much for granted. And I think that it pushes things in the right direction. It's not all or nothing.
Eduardo.
Hi, this is not my expert field, but I have a few comments. To answer your question, I think interesting you look at Australia, for example. The Australian government was one of the few that recognized actually we took the land from someone else. Therefore, we need to recognize this and pass different regulations called native titles. So in order to do extractive resources in almost entire Australia, you need to get Aboriginal permission first. They even have a court Because sometimes this chief and this other chief, they want different things and you get nowhere. So you need to have a procedure. So there are some few states that recognize that. The majority of states from, of course, Rachael has 200 times more expertise than I do in this field. Like, the issue which you have is that, for example, from many Latin American countries and even United States, the native people are considered under the protection of the federal state. And the federal state has the right to decide what to do on their behalf. Look, for example, United States. You have a lot of indigenous people in the north part of US. They certainly do not want that pipeline. And many people have objected. But the federal administration is responsible on their behalf and say, no, I see the benefit of this, and let's move forward. So as I found this is difficult, because you need to see, do they have the autonomous right to self-determine itself, or they are under the protection of someone else? In your case here, you're kind of between like Denmark and also yourself. And from a company perspective, for example, depends who is your investor. They, for example, imagine you have pension funds or the Norwegian Sovereign Fund. They have some policy that if this company is either not compliant with this and there's complaint, we should not invest in them. Of course, sometimes it's hard to follow up on these procedures, but yes, you can measure sometimes that if this company is performing really badly, and the question is how to perform. Because actually sometimes you have a very nice policy, you say so very nice things, and you don't actually do that. Who is actually controlling? Even here, our colleagues here from the NGO say that usually the issue that you have is that NGO don't have enough resources. And sometimes the government is not willing to support as well. So who is really watching who, as who is really complying with whom? That's the challenge.